Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. I will introduce our wonderful panelists this afternoon. We have 3 speakers from ADR Services, Inc.'s Trust and Estate and Probate panel presenting for you today. First, I'd love to introduce Bette Epstein. Bette Epstein has been mediating trust and estate disputes since 2000, following a remarkable career first as a licensed psychotherapist and then as a trust and estate litigator for over 30 years. She turned her focus on alternative dispute resolution and has been helping parties settle their disputes ever since. She's now available as a full-time mediator and discovery referee, and she's highly regarded as one of the Bay Area's leading probate specialists. As a neutral, she brings her unique emotional intelligence and sharp legal intellect and psychotherapy background to highly emotional probate disputes and is able to manage and successfully resolve even the most challenging and complex issues. Thanks for joining us, Bette. Going alphabetically, next we have Judge Barbara Johnson. Judge Johnson retired from the Los Angeles Superior Court in 2020 after a remarkable 27 years on the bench. She enjoyed a distinguished judicial career as a trial judge with assignments in probate, the appellate division, and the criminal department. For the last several years of her judicial career, Judge Johnson served on probate court assignment, drawing upon her prior experience as a probate lawyer to oversee a wide range of probate-related matters. Prior to her judicial appointment, Judge Johnson began her career as a sole practitioner, handling probate, family law, landlord-tenant, and criminal matters. She then joined the City of Inglewood as a deputy city attorney and later as an assistant city attorney, and she remained there until her appointment to the bench in 1993. Thank you so much for joining us today, Judge Johnson. And finally, we have Bruce Ross as our 3rd speaker on the panel today. As a preeminent authority on trust, estate, probate, and conservatorship law, Bruce brings over 40 years of expertise in resolving estate, trust, and financial elder abuse disputes in trial and through settlement and mediation. He's put these skills to work in his mediation practice for over 20 years, and he's highly regarded as an effective mediator by his peers and successfully combines effective facilitative and evaluative approaches in his work. As the author of the authoritative Rudder Group Practice Guide on Probate in 1986 through 2011, I believe, Bruce still serves as a co-author of this leading practice guide and updates it annually. That's also included on our handout materials today, select sections of the Rudder Group Guide produced by Bruce over here. Thanks so much for joining us today, Bruce.
Thank you, Katie, and thank you to all of you who are attending via Zoom this presentation. It's really great to be with you. I'm delighted to join my colleagues, Bette and Judge Johnson, with whom I've had the pleasure of working before. It's great to be back with you. Very briefly, I want to tell you what our agenda is today, what we hope to cover, and we realize we only have an hour, but we'd like to hit some of the highlights, and that is essentially a dive into Probate Code Section 850 and its related provisions, and specifically the remedy provided by Section 859 for double damages, which often is included in an 850 action as a claim for relief, but is not necessarily, it does not have to be a part of an 850 action, and we'll be discussing that in more detail as well. As was mentioned, and Katie was kind enough to mention the Rudder Group Practice Guide, which it has been my privilege to author now for many, many years. And since 2012, I've had the invaluable benefit of a co-author, Gerald Cohen. And what you have among your handout materials is the section from our chapter 15 dealing specifically with Section 850 and 859 and the intervening related sections. This is the latest edition. So with one or two exceptions, and we'll mention those as the program proceeds, I believe all of the cases we are going to discuss today are cited and in some cases discussed in those materials, which you are obviously free to refer to at any time. In addition, we have included the statutory language from Probate Code Section 850, as well as the statutory language of Section 859. So we hope that at the end of this program, we have given you some basic and perhaps not so basic information on how to handle the remedies in cases, appropriate cases that are provided under Probate Code Section 850 and its related sections. So without further ado, I'd like to turn the program over to Bette to talk about the underlying purposes of Probate Code Section 850.
So we're going to go through the basics just to give you a background of what this Probate Code section does. So typically what we think about transferring property into an estate or a trust is a Hegstead petition. And Probate Code Section 850 has basically taken over that by codifying that case. So it can be used to transfer property into or out of an estate, a conservatorship, a guardianship. That's where we see it most common. It can also be used to enforce the performance of a contract entered into by the decedent. So that could be a purchase or sale agreement that was not completed, that kind of thing. So typically a contractual arrangement that the decedent entered into that didn't complete it before death. Next is determination of joint tenancy versus tenancy in common accounts. And we see these a lot where there's a claim that no, it was not held by the decedent as tenants in common, therefore having an interest in the account, but instead was held by joint tenancy, typically with right of survivorship. So it passes by operation of law to the surviving tenant. Those come up a lot as well. And then it can be used for the surviving spouse determination of their community property interest. So it's a way of keeping assets out of a probate estate in particular, or out of a conservatorship, if the surviving, or if a spouse has community property interests that are to be segregated. And lastly, it may include claims against what we're calling wrongful takers based on elder abuse, undue influence, those kinds of circumstances. And we also see those a lot, particularly in the context of mediation, that those come up about alleged claims, alleged takings, typically of an elder against their will is what the allegation is that we see most in that regard. So next, Bruce is going to talk about standing. Who can bring a petition, an 850 petition?
Yes, thank you, Bette. And before I go too far into standing, let me note that the statute itself, although we're focused on today appropriately, I think, decedents, estates, and trusts, the statute is also available in the cases of conservatorships and guardianships, particularly with respect to issues over contracts and the like. But what we want to focus on, as noted by Bette, is claims involving property that is in the possession of, for example, the trustee or the personal representative, but somebody else claims an interest, or where the trustee has a claim to property that's held in by someone else, or where the property itself in trust is or estate is claimed to be belong to a creditor. That is a pretty broad discussion introduction to the issue of standing, because what you see here is that any interested party, and there's a broad definition of that in Probate Code Section 48, but any interested party or any stranger to the estate or trust who has a claim to property that involves the estate, trust, or for that matter, conservatorship or guardianship, has standing to bring the action. And that's clear, especially clear in the subdivision 3 of the statute, which says specifically the trustee or any interested person can bring an action in these appropriate cases. Now, those of us who've been around a while, perhaps too long in my case, remember from many, many years ago that the probate court was a statutory court. It had limited jurisdiction, and one can find some old case law that suggests you have to be, quote unquote, in privity with the estate or trust. Those decisions are, in my view, clearly discredited and no longer applicable. The issue here is, do you have an interest, whatever your relationship to the estate is, do you have an interest in the subject of the claim? And if so, one will have standing. There are obviously some cases that where that issue is questionable. And I think Bette is going to speak about, well, we'll get to that perhaps a little later, but that is the broad, very broad definition, if you will, of standing to bring actions in under Probate Code Section 850 et sec. And I think now we're going to turn to statutes of limitations.
Yeah.
Now, in connection with the statutes, the most important, well, there are two really important things to remember here. One is that, generally speaking, the statute of limitations that would otherwise be applicable to the action, that is the action that the third party is bringing, or that the trustee, for that matter, is bringing, the otherwise applicable statute of limitations applies in the Probate Code Section 850 context. There's a case, Parker, I believe, v. Walker, it's cited in my materials, that very clearly stands for that proposition. So in any and all events, one has to be aware of the statute that would apply to the particular claims that one is either defending or bringing under Probate Code Section 850. In addition, as Bette will now explain, we have to be concerned about the CCP Section 366.2 in cases involving claims or actions brought against a decedent's estate or trust.
Right.
Bette?
So this oftentimes trips people up because they don't realize that there is a very strict statute of limitations regarding claims against a decedent and the decedent's estate or trust. And that is, as Bruce mentioned, CCP Section 366.2. It's not a statute that can be waived. There's a hard line about you have a year from the date of death. So if you have a claim that you think may be viable against the decedent's estate or trust, then it's really critical that you not delay, because you'll be barred from pursuing your claim if you violate this statute. And we see it happen. People don't realize that there's a separate statute, even though it may be, for instance, enforcement of a contract that has a 2 or a 4-year statute of limitations, depending on if it's an oral contract or a written contract. That won't apply. So CCP Section 366.2 supersedes any other applicable statute of limitations against a decedent's estate or trust. So it's really important to be mindful of that.
I think, yeah, that's absolutely correct. And of course, there's a possible concern. There is a concern always too with respect to creditors' claims, which, if proper notice has been given, may well limit that statute to 120 days. Right. This is something else that, again, has to be considered. I think the simple answer to all of this is move expeditiously. Right. Don't wait. I mean, find out the basics of your client's claim or defense and proceed to move forward expeditiously, so we never have a question of whether or not you got it in at the last minute. It continues, frankly, to amaze me that so many claims have been brought at the last minute or even after the last minute, and folks have been tripped up by one or more of these applicable statutes. I think the most obvious one being the contract claims that Bette mentions, because remember, the statutes here are very broad when they talk about creditors' claims, liability accrued or unaccrued. So there are lots of problems, potential problems that need to be dealt with, and can be dealt with quite effectively by just moving expeditiously with the claims. Okay, let's turn briefly to notice. I think that's our next slide. Yes. Notice of the initial hearing. Unlike most proceedings, unlike most proceedings in probate, where notice can be given and must be given by, in some cases, publication coupled with mailing, in other cases, mailing, especially in the trust context, you'll see the provisions dealing with a notice in 17,200 at SEC. In this case, an 850 proceeding, if the claimant is proceeding against the estate or trust, or the estate or trust is proceeding against someone who is alleged to have property that belongs to the estate or trust, personal service on the personal representative and any person claiming an interest or having possession of the property must be given. This is on top of the usual requirement for notice that is in all probate cases required to be given just as a matter of statute. So it's important then to take a look at your CCP provisions dealing specifically with personal notice, and depending how you proceed, excuse me, depending how you proceed, make sure that you qualify your notice and fulfill the requirements of the section in the CCP provisions dealing with service requiring personal service. Note also, we mentioned this on the slide, the court may not shorten the time for giving notice of the initial hearing. So that should be frankly self-evident. And now, as a practical matter, given COVID and its aftermath, you're not going to get a hearing early anyway. I mean, in our more crowded courts now, we're looking at filings that go out months, frankly. But again, something to keep in mind. And I apologize, I'm still recovering a bit from a bad flu, so I apologize for coughing. But the one other thing I want to mention here, there's a statute 852 which says you can automatically get a continuance at the first hearing. I'm not sure, I mean, to permit discovery or even a response to the hearing, that as a practical matter, professional courtesy would be given anyway. But in these days, probably your initial hearing is going to be so far away that's not going to be an issue. So let's turn now to some limitations on what claims can and cannot be brought under 850. Oh, one other point before I forget, because I don't think there's a specific slide on this. If you have a claim involving real estate, consider the importance or potential application of your lis pendens. And look at those, look at the statutes governing lis pendens as well. But there's nothing wrong if you have the underlying justification to include a lis pendens in connection with a claim relating to real estate that's going to be the subject of an 850 proceeding. Bette?
So let's talk for just a minute about claims that are not available under 850. So one specifically mentioned is an unrecorded security interest in real property. So that's not going to be available. If you have a recorded interest, then you don't need to make a claim. You've already got your security and you can just act on whatever your interest may be. And then there was a recent decision coming out of the first district that we've cited here, Parker versus Schwartz, just came out from the Court of Appeal a few weeks ago, in which after a conservatorship proceeding was resolved that did not involve a general conservatorship, the proposed conservatee at that time wanted records and information that the temporary conservator had. And so was not able to get them through normal means like asking for them and communicating with the fiduciary. and so filed an 850 petition. The court denied it, said, no, that's not an appropriate vehicle for getting that information, and the Court of Appeal affirmed. So there was some creative effort to use 850 kind of outside the normal course. And unfortunately for the plaintiff in that case, it didn't work. So it's just important to know what it can be used for and what not. Generally, it's available for most claims, both coming in to a trust or estate, conservatorship, guardianship, or going out, at least to put it before the court. And then we're going to talk a little bit later about kind of the opportunity to mediate those claims. Since the three of us are all mediators, it's what we're doing a lot of, and we see a lot of these claims in our mediation practice.
Let me just throw in a couple of points here. Number one, and we apologize for this, there's a typo in the citation to the case, which might affect your ability to pull it up. There is a C between R and Z. So it's SCHWARCZ, and then you'll be able to bring up that case. The other point I just wanted to expand on a little bit in connection with unrecorded, and for that matter, recorded security interests in real property. You might want to take a look at the discussion at page 160 of chapter 15 of my text, because that cites to an old case dealing with the beneficiary of a trust deed, a state of sales, which I think has been limited now by the enactment of new statutes and the broadening of the court's jurisdiction. But consider also that a judgment lien holder may well have a claim under Section 850 if, for example, the property on which she has a judgment lien is, in her judgment, not a part of the estate. That person would clearly have standing to bring an action under Section 850. So with that discussion, with that broad overview of Probate Code Section 850, and I want to mention one other thing before we leave this. The probate court, that is more accurately saying the superior court sitting in exercise of its probate jurisdiction, has concurrent jurisdiction with the civil court over claims brought under Probate Code Section 850. And this is not an uncommon situation if you think about quiet title actions, which may well have already been filed. And indeed, if the action has been filed, if civil action has been filed and it's brought to the attention of the probate court, as presumably it would be by the person who filed it, as a defense to the probate court hearing the 850 petition, there's a mandatory abatement of the probate code 850 proceeding in favor of the pending civil action, solely subject to one finding, a key finding by the court, which is that if the action was filed solely for the purpose of delay, abatement becomes discretionary. So with that, let's turn now to 859 and double damages. And maybe it means double damages and maybe it doesn't.
Thank you, Bruce. Before you is the code itself, and I want you to highlight 3 sections of it. I'm not going to read it, you can all read, but the first one is bad faith. I'm going to talk about that in a few minutes. The second is the phrase twice the value of the property recovered. And then lastly, we should keep into consideration the fact that reasonable attorney's fees and costs can also be a part or in addition to Section 859, which we'll put in quotes as double damages. Both double and damages have been disputed in the cases that will follow. Okay, next slide then. So thank you. So 859, first of all, we have to remember that to recover, you have to request it in the 850 petition. And it's not solely limited to probate court, as Bruce and Betty has already said. It can be in other civil, another type of civil cases. But it's worth mentioning that it should be brought, the 859 damages, we'll put that in quote also, should be brought in the 850 petition. The next slide, please. Notice. We've talked a little bit about notice from Betty and Bruce, but the notice that must be given in the 850 petition must include a description of the relief sought under the 859, sufficient to provide adequate notice to the party against whom the relief is requested. And so, of course, it gives you what should be included in that. That is a description of the property, a statement advising the interested party may file an answer to the petition, the basic notice requirements. And that's under 851.3. And we should keep in mind, it may have already been mentioned that basically if there's no notice, court doesn't have jurisdiction. Thank you. So this slide talks about the presumption for fraud or undue influence where it applies. It should be noted that the probate code presumes certain transfers to be in bad faith and to be a result of certain undue influence. And generally, as you might guess, the presumption is affecting the burden of proof. If you're related to any person by the third degree, if you're a caregiver, if you're a drafter of the instrument itself, if you were once a caregiver, now a spouse, newly spouse, or if you care for the person and then there's a transfer within 90 days of your care, all those possibilities arranged can have happened, and those presumptions are of fraud. So, and those are all in 21-380 of the probate code. The next one is of course, there's always things that are not included in that. And so an example is under probate code 21382, which talks about donative transfers to a federal, state, or local public entity under 5013 or 501c9, among other things, or where the estate itself is less than $5,000, or if the estate exceeds, right now the amount is $166,250. So those are some examples where the donative transfer are excluded from the presumption of fraud. In 21384, there needs to be a certificate of review, which talks about an attorney reviewing the transfer, an independent attorney, not the attorney that wrote the instrument, or drafts the document, and can't be an employee of the attorney that drafted the document, and it has to be outside the presence of the proposed beneficiary. So it's a way of making sure that the person that's making the transfer or making the documents, which is the trust or the estate, is not overly influenced, and a certificate of independent review helps. And then the last one is 21385, where at death is excluded if at death there's a transfer or other instrument that's not subject to Family Code Section 721. That is, usually it's between a spouse in terms of a will or revocable trust, and so it's not subject to the presumption of undue influence. So those are some exceptions. Next slide, please. And of course, so this is probably where we'll have a little bit of discussion, talking about formal proof of bad faith. Remember, I told you to underline the bad faith section of 859. So we're going to find out that there's no separate finding, according to Keating versus Keating, which is cited, is necessary where property is taken through elder or dependent abuse. under the Welfare and Institution Code, in this instance, 15610.30, subdivision A, subdivision 1. So there's no separate finding for bad faith that's necessary prohibiting the taking of property for wrongful use or with intent to defraud. You don't have to have bad faith. If it's an elder, it's an abuse of an elder, or a dependent person, you don't, according to Keating, you don't need bad faith. But in the second case that's cited, Levin versus Winston Levin, says recovery of damages for financial elder abuse as defined by the Welfare and Institution Code requires a finding of bad faith. So there seems to be some dispute as to whether bad faith in itself is required.
That is indeed, those two cases are a reflection of a split in the authority. I was particularly interested to read the Keating v. Keating case, which held, as Judge Johnson just mentioned, that if you have a finding of financial elder abuse, bad faith, a specific finding of bad faith is not required, in contrast to the earlier case of Levin. So in reading the Keating case, I was interested to see how the justices in that case distinguished Levin v. Winston Levin, which is the earlier case. And absent a Supreme Court decision on this, which I'm not expecting anytime soon, I'm not aware of any case that's presented this issue. I would submit that the Keating case has the better rationale here. And the reason is that Keating looked quite carefully at the statute. And we might want to put the statute back up if we can for a minute, Katie.
The 859 statute, yeah.
Yes, 850. All right, take a look at this. The first sentence, if a court finds that a person has in bad faith wrongfully taken, okay, put a note, one, put a one there, has one in bad faith wrongfully taken, concealed, etc. And then go down 4 lines and look at the second or has taken, concealed, or disposed of the property by the use of undue influence in bad faith. Put a 2 on that first or there, or has taken, concealed, etc. in bad faith. And then look at the next or and put a 3, or through the commission of elder or dependent adult financial abuse, etc., as defined in the Welfare and Institutions Code, they're liable for twice the value of the property recovered by an action. And what Keating is saying, and I think it's persuasive. I'm not the Supreme Court, so obviously I'm big surprise there, right?
Not yet.
Yeah, well, I know, not ever. But I am a quote unquote commentator for what it's worth. You know, I've been around too long. But in any event, what Keating says is the third, those are three disjunctive provisions. Yeah. And the third one, which said, and they're right, it says or through the commission of elder or defendant adult financial abuse. And unlike 1 and 2, it doesn't say in bad faith. And that is the rationale, because Keating respectfully disagreed with the Levin court, but stated in detail why they disagreed. And I personally find their reasoning persuasive. So again, if you're in the 1st district, which is up in your neck of the woods, Betty, Contra Costa, you've got binding authority. And if you're in Orange County, the 4th district, you're going to have to tell the court, trial court, good luck, to ignore the 4th district decision in Winston v. Winston Levin in favor, of course, Keating. Now that presupposes you're the plaintiff. On the other hand, you know, if you're defending the case, you're going to fight like hell for the fourth district reading. But in any event, I think it's a very interesting issue that for now at least we have to acknowledge if we're arguing it, both sides of that issue. So
Okay, well, let's go back to I'm not interrupting you, Bruce, but
no, go ahead.
we can go back to what does double damages, because after this disagreement, we have another disagreement. The next slide, please. So what does double damages really mean? And we had to underline certain portions of the 859 that we just put up. And you will see that in that there's no first of all, there's no damages, the word damages in it. And there's no double, it says 2 times whatever's recovered. And so we're now with the issue of what does the recovery of twice the value of the property mean? And there is some split of authority on this issue. 859 provides a recovery, as we said, of twice the value of the property taken in bad faith. And Bruce has just talked about what bad faith is bad faith really required in every type of unlawful taking. We come to the state of Cross, KR, well, it's up there, which says that there was a bad faith taking of the property. An interesting note on this case is that the person, for me, other than how we're gonna split up or determine, well, we might as well go back and say, the respondent withdrew about $200,000. It was returned, and the respondent was ordered to deliver, in addition to that, twice the value of the property recovered, which was about $400,000. I'm just rounding the numbers up. I'm rounding up to a court-appointed personal representative of the estate. And so the court says, nothing wrong with that. And although the respondent is saying, well, that's triple damages. There's another case that we're going to talk about, but before we leave Cross, the point that I want to make in this case is that the court determined that there was a bad faith taking. The interesting note in this case is that there were no actual damages needed to be awarded to anyone. In other words, the sums weren't given to a representative, they were given to a representative of the estate. They weren't given to a particular person. And it was left to the court to decide later how it would be distributed and who had the right to the property. The other thing that was different in this case was the court says, hey, you can't pay, not my problem. An inability to pay is not essential to an issue of statutory penalties. We'll order the penalties and you can take that up later in mitigation, mitigating what you might owe. So the ability to pay can be taken up later in mitigation. Now, so now to the conservatorship of Ribal. Well, we're just going to skip Hill, but in Hill, basically, the penalties were distinguished from punitive. Hill says, this double or twice the recovery is not a punitive measure. And even if it were, under the civil code, you can have both. You can have under civil code section 3294, and you can have another action under 859. But, and the penalty that is twice the recovery is distinguished from what is punitive damages. And so that's what Hill basically talks about. But to Ribal. Ribal was the case in 2019. And as is most cases, it had been appealed twice on various issues, and it came before the court. The amount awarded was about $115,000 in uncollected costs and rents and such. There was an offset, then there was a judgment for about $80,000. This amount was doubled to $160,000 about, and then some personal injury damages of $20,000 was added to it, plus costs and fees for attorney's fees. So the conservatives' argument was that because the last sentence of the probate code 859 states that the remedies in the sections are in addition to any other remedy, the amount should be calculated by first assessing the amount of the damages, which is $80,000, then doubling the damages, which came to $160,000, and then assessing separately an amount added to that for a total of $240,000. So 1 plus 2 equals 3. The court there found that this contention was unsupported by the law, and if the legislature had intended to say triple damages, they knew well how to delineate such. So they could have said, you know, it would have written something like the person shall be liable for 3 times the value of the property recovered. And so that case then, because I said there's a split, is in opposition with Ashlock. Excuse me. And again, Ashlock in 2020 went up on appeal several times. Excuse me. And that finding, relevant to this appeal, Ashlock won. The judgment including findings of forged documents. The person created some partnership, took the partnership, and that were never existed, took the money, and respondent was found to have committed fraud in the setting up of the partnership. So in Ashlock 2 dealt with attorney fees, and then we come to Ashlock 3. Court of Appeals held there that the order requiring attorney, in fact, to return property to the estate did not prejudice full penalty of twice the property's value for wrongful taking, concealment, or disposition. So she took the property, you had to return the property, and then you, on top of that, you had to pay double or twice the value of the property recovered. So these cases are multiple properties. So this can get to add up to millions. In this case, it added up to over 5 million just for the property that was taken and returned. And then a penalty of 10 million about was ordered. And he argued that the petitioner couldn't recover misappropriated property under 856 and then be awarded twice the value of the recovered property as a penalty. And he says, well, what if we had a ring? And the court says, well, if you had a ring, you took it, you would return the ring, and whatever the value of the ring was, you'd have to pay that. It's no different in requiring return of property and then 2 times the value of the property that's returned. So there's a split in that, whether it should be 3 times actually or 2 times. That is, twice the value is covers the initial return of property. What do you think?
I'm reminded of a line from The Man of La Mancha, which you may all recall, a wonderful Broadway play, musical many years ago, where the Grand Inquisitor has concluded his inquisition of Don Quixote and his colleague, Sancho Panza. And he says, I find you guilty and I fine you everything you own. And Don Quixote says, wait a minute, how can you do that? And the Grand Inquisitor says, because it's not practical to take more. So at some point here, if you have all these damages together, you have a real question whether or not the losing respondent or defendant, as the case may be, is ever going to be able to pay it. So we need to consider that. But it's fair to say, clearly, based on all of this discussion, we have a couple of issues out there, including, can you, in fact, obtain double damages and the recovery of the property, or is it inclusive double damages? And as importantly, do you, as a plaintiff or petitioner, do you or do you not have to have formal proof of bad faith? Those two issues have been decided by appellate courts, but they are not in agreement. So it's something that I'm sure we'll be dealing with as we go forward.
Yeah, Mr. Ashlock agreed with Cross and said, hey, it's only fair you return the property.
Right.
It's only fair you be penalized.
Yeah. So it occurs to me, because we do want to spend a little time talking about tips. Before we get to that, since it looks like we have a little time, I thought I'd pick up these questions that I see on my screen. And Barbara, Betty, please jump in if you think I'm off base here. The first question is, does CCP 366.2 include claims against real property? I think the answer is yes, but then it goes on to say, for instance, through an abstract of judgment or other type of lien. As we said before, if you have a judgment lien, then I do not think that 366.2 is applicable. I think what you need to be concerned about is execution of the judgment and statute of limitations precluding execution after, I believe it's 10 years unless the judgment is renewed. But that gives me an opportunity to mention one other little issue here, not little, but a potentially significant issue. We talked about this earlier, and I mentioned I don't know if I mentioned it specifically, but was alluded to the sales decision, SAYLES, which is mentioned in the text materials that you have, which said that the beneficiary under a trust deed didn't have a sufficient interest in the property. That is an older case, and the statute has been modified a little bit, and that particular case might be good law, but as I think we also mentioned, that a judgment creditor may well have a claim under 850 and theoretically could be, well, I'm not sure it could be subject to the statute of limitations or not, but they certainly have standing to bring the claim on the grounds that the property that is otherwise claimed by the trust or the estate doesn't belong to the estate or a trust. And one other point here, there is an argument that 366.2 doesn't apply if the petitioner is seeking a resulting trust. Now, this is a state of Yool, YOOL, 151, Calab 4th, 867. And that's cited at page 162 of your excerpt from chapter 15. It's important to look at that, though, in conjunction with the discussion in chapter 8 dealing with creditors' claims. So it's a little bit of a tricky issue, and there is a citation here in chapter 15 to chapter 8 of our book, paragraph 99.2. So again, if in doubt, move promptly. You're not going to have any, unless you file without probable cause, you're not going to face problems, judicial problems at least, if you file quote unquote too soon. It might get dismissed without prejudice, who knows, but you're not in the same boat if you file a little too early than if you file a little too late. Then there's a question, I think, in response to our discussion of notice. Given this notice period, how are some courts approving ex parte 850 petitions? I haven't heard of any court approving an ex parte petition under Section 850. In my view, that would be void, absolutely void, as beyond the jurisdiction of the court. Now, it's important to note there are some pre-hearing remedies that may, in appropriate cases, be available, such as an attachment, but you've got to go through all the hoops and have all the bells and whistles to get an attachment, or a pre-hearing, perhaps surrender order if the property is in danger of being moved. But I'm not aware of any case that has approved a 850 petition on an ex parte basis. There,
I'm not either. It's hard enough to get ex parte petitions approved.
and it's
When there's good reason for it.
anything approved. This is interesting. Fraudulent deed recorded on decedent's property cannot locate LLC or name of wrongdoer. How do we serve notice? I think that probably takes, ADR Services is going to answer this question. Does that mean me? Oh, I see what you're saying. Well, all right, I'll give it a shot. It looks to me like you might have to resort to quiet title. And I'm just thinking out loud whether or not you could try under 850 and make a suitable finding for the court, or ask the court to dispense with notice, formal notice, on the grounds that you've done everything you could to find the person, and
Or to do it by publication,
and-
to
yeah,
get
and
permission to do it by publication. That's what I would think
yeah.
would be what
So
the
I think-
court
I
might
think
direct.
I think that's your best bet there. Again, we can't answer case-specific questions, but in general, if you can't find the person, but 850 still applies, you can do your best, and then tell the court you've done your best, and ask the court to give notice by publication to anybody
Mhm.
might have an interest who can't be found. So I think those are all the questions we have. Oh, maybe we have a couple more here. Let's see.
There's one long one that I'm not sure we can quite get through it at this moment. Maybe at the end, what I would suggest is we complete kind of the program as we designed it. And then if there's more time, we're willing to stay after the 1 o'clock cutoff and answer questions to the extent we can.
That makes good sense. Then I can throw that question to somebody who can answer it.
So are we going to go to the tips? Judge Johnson, do you have some good advice for folks that are listening?
Well, I think that what's up there is that if you stipulate to 859 damages will not be sought if the settlement is agreed to. These are tips for mediation, why mediation helps. And generally, stipulation is always better than trying to try an 859 case. And I have tried an 859 case.
And what I'm saying is that when there's any claim of kind of a wrongdoer getting access to assets, there's always claims of elder abuse, and there's always claims of 859 damages. And what I see and what happens in settlement in the context of a mediation is that that's something that can go away pretty easily, because it's really tough to prove both of those things unless you've got really solid facts. And so I see it being used as a negotiating strategy to say, okay, we've alleged 859 and we've alleged elder abuse, but we won't pursue those remedies in the context of a settlement. And that's what I'm seeing happens very often.
Yeah, I think that bad faith is tricky, because unless it is, you do knock it out in settlement. Especially if you have a trustee that layperson, it's hard to find bad faith if they've done all they can. They keep the checkbooks and send you the checking accounts and don't really do an accounting that well or something like that. So better to settle it that way.
Right.
Yeah, I think all of that is true. At the same time, sadly, there are still some bad actors out there. And in an appropriate case, if one has probable cause to pursue it, I think it needs to be pursued. I agree completely, however, with Bette that more often than not, it is not something on which a mediated settlement should hinge,
Right.
Just because it is difficult to prove, and you're going to get an appeal,
Right.
In any case. So,
Right.
but that's true of so much of this. But again, it's a consideration not to be lightly dealt with one way or the other. By the way, on that point, I am going to answer one of these questions, which is, if the holder of an asset returns the asset after filing of the 850, can you still proceed with obtaining double damages? I have a case, but I don't have it at my fingertips. I can either, Katie, if it's appropriate, add it at the conclusion of the program, or if the gentleman who asked that question wants to send me an email, I'll send a citation to the case. I just saw it in passing while I was preparing for this program, but there is a case, I believe, and I don't have it in front of me, but I believe that the answer is there is still a viable claim for double damages, because that's this, and this makes some sense to me because the statute doesn't focus on what happened after you took it. It just says if you took it in bad faith. But there is a case, I believe, that I saw, a recent case that I just saw in connection with preparing for this program, and I'll try to pull up that citation.
And I do see claims that are after having given notice that this is really an estate or a trust asset that needs to come into the estate or trust, that it's withheld, that the argument is that that's bad faith to withhold it. So I had a case recently in which there was a joint account, and it was admitted that the account, that the assets held in the account were all belonged to the decedent. And the other person who was named on the account had title, was there only for convenience. And yet, despite an 850 petition, that person refused to turn over the assets. And so clearly there was an argument that withholding the assets under those circumstances was an act in bad faith. And that's where these cases come up a lot, actually, are in joint accounts, and who are the rightful owners of those accounts and what the disposition of them should be.
And I have a case like that now where that is the issue. Was it bad faith to fail to return some property after a court ruled that it should be returned? And if you look at the statute, again, it says if a court finds that a person has in bad faith wrongfully taken, concealed, or disposed of property. Right. Now, I suppose the argument would be, well, in refusing to give it back, you're concealing it. I mean, it's a bit of a stretch, but certainly it's a legitimate issue.
But was the question, and maybe I misunderstood the question, I didn't read the question, but was it about the property being recovered? Once you recover it, can you still?
Oh, yeah, no, I may have misread it. The question was if the holder of the asset returns it after the filing of the 850. So I'm assuming the implicit understanding of the questioner is that the person realized, hey, I shouldn't keep it. I'm giving it back pending determination. Can the petitioner still proceed with trying to obtain a double damage recovery? As I said, I'll have to pull up the case, but I believe that the answer is yes.
And I think at the least they would try and recover attorney's fees and costs and having to file the 850 petition.
Certainly, yeah. And in fact, that would seem to be a pretty strong argument for getting them to. Hey, look, if I hadn't gone forward and spent the money to get it back, I would get my money back.
Right.
So,
our last slide was practical applications, and that's kind of what we're talking about now, of where we see these issues come up. And I think we have about 1 minute to talk about that. But I see it a lot in my mediation practice. It has to do with both in accounting, trust accounting disputes, where funds are allegedly used for a wrongful purpose, and particularly for the benefit of the trustee. I see that a lot, as well as with these joint accounts and arguments about who is really the rightful owner of the assets in those accounts. So, Katie, are you're appearing?
I'm making my appearance to indicate that we are at the conclusion of the hour.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.,